All right. I think we're ready to roll. The gentleman that's in the Michigan Department of Corrections facility, can you tell me your name?
My name is Irvin Reynolds.
All right,
And
thank you,
I'd like to say that coming in, that I'll make a special and limited appearance just to challenge the subject matter jurisdiction of the court. And I'm saying that the court doesn't have jurisdiction of the principal subject matter, which is the writ of attachment that the prosecutor's office filed.
All right, your objection is noted. 1 second here. All right, this is State of Michigan versus Irvin Reynolds, case 24060877001. Today is the date set for a bond redetermination hearing. Can I have appearances, please?
Good morning, Judge. Steve Vincent for the people, P71917.
Good morning, Jessica Shipe, number 81798. On behalf of Mr. Reynolds, sir, can you please state your full name for the record?
She's not my lawyer, Your Honor. This is an arraignment proceeding, right?
Mr. Reynolds, do you wish to represent yourself?
Is this an arraignment proceeding?
This is sort of like an arraignment. This is like a you are arraigned, and this is a hearing to see if the bond.
Hold on, you said I was arraigned?
Okay. So,
did you just say I was arraigned?
Your Honor, may I step in? I see some notes here.
Well,
I haven't been arraigned.
Can I stop everybody right now? Ms. Shibe, if Mr. Reynolds is indicating that he's not your attorney, then I'm going to ask that you hold tight right now. Mr. Reynolds,
I haven't been arraigned.
Sir, listen to me for a second. I'm trying to straighten this out. You indicated that you have not been arraigned?
Mm-hmm.
All right, 1 second. Let me take a look at what's in the file. Hold tight.
Yes, and I do have notes, so not on behalf of him, just to help the court.
I appreciate that. But let me see where we can get to. So the system says that it was arraigned, but if that's a mistake, Ms. Shibe, you indicated that you had some additional notes.
Yes, so the notes that I have, it looks like Mr. Reynolds did want to represent himself. He was spoken to and told his rights and all. And it looks like he was Okay, it looks like he was objecting to being arraigned without being brought in person. It says that he wanted to be arraigned in person and he was objecting, but I do see that a bond was given and new dates were given. So it said no video arraignment. So I believe it was done without, he wanted to
Your
come
Honor.
in person.
Well, I would say this, Mr. Reynolds, I would say this, that's fair. If you want to be arraigned in person.
Hold on, wait a minute.
No, stop. You have the right to be arraigned in person.
They cut
Listen to me. I'm going to stop your audio because you're not listening to me, and I'm not going to go back and forth with you. I'm indicating if you want to be arraigned in person, I am going to order you arraigned in person. And we're going to stop all this. If you stop talking over me, we wouldn't have this back and forth. All right. So I'm going to set an arraignment date. Let's see, today, the next date they have in front here for, looks like there's an exam date scheduled for January 2nd, 2025. We're going to have the writ signed for you to be arraigned on that date. We'll see if that's enough time to transport you to 36th District Court for your arraignment, and then we'll take a PCC from there. So we'll schedule this for an arraignment January 2nd, 2025 before Judge Sabri. That's going to be your next date, and we're going to have a writ to bring you down to 36 for that hearing. That concludes the hearing. Well, that was easy. All right. Person in interview room 10, can you tell me your name?
Justin Wilson.
All right, Mr. Wilson. 1 second. It's the State of Michigan versus Justin Wilson, case 2406111-301. Today is the date set for a bond redetermination hearing. Bond is set intentionally unaffordable. Appearances, please.
Thank you, Judge. Steve Vincent, P7191.
Jessica Shive on behalf of Mr. Wilson. Mr. Wilson, please state your full name for the record.
Justin Dion Wilson.
All right, bond is set intentionally unaffordable in this matter. Ms. Shive, as to bond.
As to bond, Your Honor, I will start by saying that we see the allegations, the charges, we understand their seriousness, Your Honor. But Mr. Wilson has no prior criminal convictions to our knowledge. He's not on probation or parole or nothing pending. He's 32 years old. He's a lifelong resident of Michigan. He's a college grad. He's a manager at his job from 5 p.m. to 3 a.m. And Your Honor, the report is interesting here. It appears that the complaining witness allegedly stole my client's car. And then the rest of the allegations against my client that you could see. And then when the police go to the hospital to speak to the complaining witness lies and says that he got a car from a friend but could not provide his name, which goes to credibility of the witness, you know, lying right there. Your Honor, also when my client, the police say that there was a gun found, no round in the chamber, empty magazine. These are allegations. You have the report. I, again, understand the seriousness of this, but my client is 32 years old with not on probation or parole, nothing pending and no priors. These are all allegations on both sides. If any of this is true, we understand and my client understands that you let the police handle matters like this and you don't take matters into your own hands. But these are allegations. He's presumed innocent unless proven guilty beyond reasonable doubt. Again, the complaining witness alleges the one that steals the car and then, you know, lies to the police. But we are here for redetermination. They'll have, you know, my client will have his day in court. Everything will come out. But for purposes of bond, I'm gonna respectfully ask the court to reduce the bond or give a personal bond. And if the court is not inclined to do that without a tether, given the allegations, then we understand. I just ask that he be allowed to go to work so he doesn't lose this job that he has. It's a good job and he has no priors, Your Honor. And there's no reason to have any flight risk here. So respectfully asking for a reduction in that bond, any bond amount is going to be unaffordable.
All right, thank you very much. Mr. Vincent, as to bond.
Judge, lead charge here is the assault with intent to murder. We have an individual who actually warned the police prior to this incident that they better find the individual that took his car before he did. Well, unfortunately, he ended up finding that individual before the police did, and he ended up shooting at that individual in his car, allegedly the individual who ended up taking his car. He actually shot at his own vehicle, and then he struck that individual that allegedly was driving his car. The incident's caught on video. We have an admission from this defendant as well. We do feel as though there's a high likelihood of conviction here. It's pretty scary when people take these kinds of matters into their own hands. I mean, quite honestly, we could have been here for a murder charge. So respectfully, we find him to be a danger. We're asking you to continue this bond.
All right, one moment. They said $100,000 cash as surety. See that there was a warrant in the system for a previous firearm violation. CCW. I don't know what happened with that back in 2020.
If I may, Your Honor.
Mr. Wilson,
Yes, sir.
I know you want to talk right now. If you want to speak through your attorney, I can put you in a room so you can talk with her so you don't say anything that might possibly incriminate you. That might be the best way to proceed on this matter, but I'll let you go if you want to go, but you know, maybe you want to tell her what you want to say and let her say it.
It was really just pertaining to the that warrant and those tickets. I don't even know how that's still on my record. That was supposed to got tossed out when I had went to court for all of that stuff. All that was taken care of. I don't know how that's still there.
Yeah, I know I did the exam on your other one. So, you know, I got some familiarity to it. I can't pretend like it didn't happen. So understanding this is at least the second gun offense at this point, you know, somebody shot, and reading the investigator's report, you know, this happened on a street. Somebody else could have been hurt. That car crashed into something else. You know, understanding the circumstances, understanding that, you know, maybe there was justification for this, but I'm here to protect the safety of the public at this point. And I can't trust you out here without firearms and weapons right now. So bond is going to remain the same in this matter. I do believe that there's been a situation that's created a very high, high level of danger to the community at large. You know, I understand as a most of those situations, you see somebody with your car. I've had my car taken a couple of times. That's not something you know, you easily take, especially when you see it. But, you know, there's something going on here right now. I'm not comfortable with reducing the bond. So bond is going to remain the same. Sir, your next date is, excuse me. January 2nd, 2025 before Judge Taylor. January 2nd before Judge Taylor.
Okay.
All right, thank you, sir. Gentlemen, that's in interview room 52. Can you tell me your name?
Bryson?
Bryson?
Yes, sir.
All right, thank you, Mr. Bryson. 1 second. This is State of Michigan versus Don Fryson, case 21044-82201 and 210441501. Today is the date set for bond redetermination hearings. Bonds are set intentionally unaffordable. Appearances, please.
Good morning, Judge. Steve Vincent for the people.
Jessica Scheib on behalf of Mr. Fryson.
All right, today is the date set for bond redetermination hearings. Bonds are set intentionally unaffordable. Ms. Scheib, asked to bond.
As to bond, Your Honor, we're going to ask the court to keep the bond as is. Mr. Fryson is worried that he can't make it to his court dates, and that is what happened before. He said he didn't have a way to get there. He also didn't have a phone. I believe he did provide a phone number now, but he worries about the Wi-Fi and all. He is going through a difficult time. He is homeless. He does have his mother's address, but he indicated to us that his concern is that he's going to get another capias for not being able to make it to court. So he wanted to ensure that he's at court because he wants to put this behind him. And I explained to him he can make prior arrangements and all, and he said there's no way. He's trying in the situation that he's in right now. The best way to ensure that he's at his court date is to stay in custody so they can bring him in. So at this time, I'm asking the court to keep the bond as is. He's had multiple capiases in both of these matters, I believe, due to the transportation issues and arrangements to make it to court.
All right, Mr. Vincent, any objections?
Judge, the people have no argument regarding this matter.
All right, bond remains the same. Mr. Fryson, sir, I know I'm sad to hear that this is the only way that you can ensure yourself to get to court, but you know, I respect your wishes. The next date is January 7th, 2025 at 8:30 before Judge Garrett.
All righty, thank you.
All right, thank you.
Thank you, Your Honor.
Thank you. Gentlemen in interview room 11, can you tell me your name?
Larry Garrett. Larry Lamar Garrett, truck.
I got you, Mr. Garrett. I was on mute by accident. This is State of Michigan versus Larry Garrett, case 24061151101. Today is the date set for a bond redetermination hearing. Appearances, please.
Thank you, Judge. Steve Vincent for the people.
Jessica Scheib on behalf of Mr. Garrett.
And good morning, Mr. Garrett. Today is the date set for the redetermination hearing. Miss Scheib as to bond.
As to bond, Your Honor, these are allegations. I understand serious charges and the way that it was charged. My client indicates that this is all one big accident. He is a lifelong resident. He has 3 kids. He lives with family. He's not on probation or parole or anything pending to my knowledge. His prior is from 20 years ago for and it's non-assaultive. He is employed, and I'm not aware of any capious history. This bond is very excessively high, 500,000 cash, surety, GPS tether, house arrest, unaffordable. I understand the charge here, at least, to count both these counts, Your Honor, but they are allegations. He is presumed innocent unless proven guilty beyond reasonable doubt. The court has the report, and my client does suffer from mental illness, Your Honor. He is on medication for that. So respectfully asking the court to consider a reduction in the bond, and if the court is not inclined to do that without a GPS tether, house arrest, then we understand, Your Honor. He does home improvement a few days a week. His hours vary. I would ask that he be allowed to go to work, but if the court at this time is not going to allow him, but is comfortable releasing him, and he has to stay at home, he has a place to stay. It's his address, and I'm not aware of capious history or any assaultive history, Your Honor.
All right, thank you very much. Mr. Vincent Esteban.
Judge, it's the people's feeling that this is undercharged. We think it should have been an assault with intent to murder. We have an individual allegedly hitting somebody with a vehicle, running them over, dragging them down the street, and then repeatedly reversing the car and moving forward. Now, the entire incident's caught on video. The individual ended up sustaining serious injury, needed hospitalization. The parties know each other. We feel as though there's a high likelihood of conviction. In addition to this, for what it's worth, the defendant has 2 warrants out for him out of Highland Park, one for trespassing, most recently one for an OWI set September 9th of 2024. Respectfully, we feel as though the $500,000 bond is appropriate.
1 second. Matter is charged assault with intent to do great bodily harm, which is a felony assault charge. Mr. Garrett, I don't believe has any assaultive priors from what I can tell. The defendant is alleged to run over his friend, and after running over him or dragging him for half a block, I guess tries to get him off of him by going back and forth over him a couple of times and then driving off. I do believe that this is a highly, highly dangerous situation. I don't know why anybody would consider that a safe environment for anybody on these streets. Leaving someone like that, causes me to pause. I'm gonna keep the bond where it's at right now. I would note the charge GBH. That's the people's prerogative of what they charge. So I don't know how the people could take a position that it should be charged something else when they charged it. So I'll leave it at that.